This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Yes, sir. In fact, Learned Advocate General, when the matter came up on 16,
Yes, my lord.
we passed an order noting that in paragraph
Yes, my lord.
of the order dated 10th April,
Yes, my lord.
directions have been issued to the appropriate authority of the central government, as also in para 11 and 12.
Yes, my
The
lord.
Central Standing Council appeals submitted, affidavit has been sworn in, and it will be filed on the next year.
Yes.
And in respect of
My
the
lord,
state,
I'm sorry. Yes, my lord. I'm so sorry. I'm so sorry.
a direction was issued in para 14, for which the
Right, my lord.
Common Council day before yesterday requested time because you are appearing in the matter and awaiting instruction. So we said today we will
Yes,
consider
my lord.
what is the stand of the central government, where the direction issued in para 10 of the order dated 10th April, 10, 11 and 12.
Yes, my lord. Yes, my lord.
Yes, sir.
But may I only make one submission, my lord?
Yes.
I think, my lord, this matter will take some time. Whenever it's convenient for the court, it may be tomorrow, day after tomorrow, my lord. Let us, my lord, do it, my lord, physically, my lord, subject to what my learned friend appearing for the petitioners submits, my lord.
We will do that. We like to know the stand of the central government.
Yes,
We have already filed the copy of the Honorable Second Judge's copy and the original may hand over. Possibly a scanned copy has been
Yes, I got it.
the Chief Justice.
Now, sir, if you can have the 10th April order side by side.
Yes. 10th April order and the direction issued upon us, we have given in detail para-wise in the report. Kindly allow me to place the report in detail, because this is required. Because there are, my lords were under the impression that only in respect of 4 districts the inquiry was made, and as such something was found. Now I submitted on the last occasion, and that is also recorded.
Yes.
Apart from the 4 districts, there are other districts where the inquiry was won. And if my lords come to the writ petition of 555, that is also listed before your lordships. Their inquiry report or detailed inquiry report of the Rural Development Department was filed. Apart from these 4 districts, there are other districts. Now, in the report which we have filed pursuant to lawsuit direction on 10th April 2025, it starts from actually the answer to the questions raised by your lordships from para 3 onwards. No, my lord, so I'm sorry, my lord. Not 3. Actually, para 5 onwards. Para 4 onwards.
4 onwards.
Before reply, my lord, I'll still have to read it in detail, the para-wise, on line by line, because before replying to the specific queries put forth by this honorable court, by the solemn order dated such and such, having reference to the respondent number 1, begs to submit as follows: that under Mahatma Gandhi National Rural Employment Guarantee Act 2005, the fund released to the state is a continuous process, and central government is committed to making funds available to states for implementation of the scheme. Funds are released to the states, union territories periodically in 2 branches, with each branch consisting 1 or more installments, keeping in view several factors such as sanctioned labor budget, demand for works, opening balance, pace of utilization of funds, spending liabilities, overall performance, and subject to submissions of relevant documents. It is also pertinent to mention here that a robust online platform called MIS Regrassoft is in place, to which updation of information at every level is done by the concerned state, union territory, and on basis of the information of Regrassoft and funds are released as per the provisions envisaged under the Act. Central government releases 100% of the wage payment directly to the bank accounts, post office accounts of the beneficiaries through the National Electronic Fund Management System thereafter. Now, this is the explanation given as to how it is being disbursed. Now, para 6 onwards kindly come. In reference and or reply to the paragraph 10 Roman I of the solemn order dated such and such passed by the Honorable Court, the respondent begs to state that as per Rule 238 of the General Financial Rules to 2017, all interest or other earnings against grants in aid or advances other than reimbursement released to the grantor institution should be mandatorily remitted to the Consolidated Fund of India immediately after finalization of the accounts. Therefore, the question which fell from my lords on the last occasion was, what was the recovery of misappropriation of the amount where it has to be transmitted? Now, this is the answer in the Consolidated Fund. Now, then such advances should not be allowed to be adjusted against future releases. In view of the above, the state government should deposit the recovered amount into the Consolidated Fund of India. Accordingly, the state government should remit the recovered amount through a demand draft drawn in favor of the Pay and Accounts Office, Ministry of Rural Development. The last question is answered.
One clarification. Sir, this inquiry, now we will not go into the other districts because in the next paragraph, I read the affidavit, full affidavit. Other paragraphs you have said, another set of team has visited, etc. Another 15 districts are going on. First, for the time being, we will restrict to 4 districts. If this amount, according to the central team or visiting team or whatever team was constituted by the court, etc., certain irregularities have been found. Admittedly, there were irregularities. Therefore, the payments made out to those people have been ordered to be recovered, remitted to a particular nodal officer's account. But their consistent case of the petitioner was, there might have been 10 bad apples, but still there are people who have genuinely worked. They are not being paid. That's the, sir, from the beginning of so many hearings, we are trying to make that issue clear. We are not saying anything about your inquiry into irregularities, illegalities, which you are bound to make. No person can benefit by a fraud committed. But if there are 10 people who have genuinely done the work, why do you
we are not standing in the way, but what two aspects we are, two aspects.
You can't get it back, sir. If you
would it be Loss's pleasure to see once in the list paragraph 9? Paragraph 9 of the report.
Page 10.
Page 10. In reference and a reply to the paragraph 13 of the solemn order, the Honorable Court regarding release of pending wage and material payment under Mahatma Gandhi such and such, which arose prior to date of Ministry's letter dated 9th March 2022, the respondent begs to state that due to non-compliance of various directions related to transparency and accountability, the request of the state government for upward revision of labor budget for financial year 2021-22 was not agreed to be the empowered committee in the department. Therefore, payments towards wage, material and administrative components for the period prior to 9th March 2022 have not been made. In this regard, the latest action taken report dated 23rd October 2024 and updated action taken report dated such and such, taken report such and such, from the state level been examined and further observations have been conveyed to the state detailed letter dated such and such for necessary compliance and clarification as stated above. Photocopy of such and such. Therefore, my lord, the question of payment to those who have really worked, we respectfully agree with your lordship. Now, what is the case made out by the Khet Majur petition, the first petition before your lordship? Applications were made to the district magistrate in the concerned districts. Now, who is to assess whether these people whose lists are being enclosed, whether they have worked or not?
Not on that.
with deepest respect to my learned senior
Please
friend,
allow me to
at the
finish.
moment we are not agitating that issue at all, sir. With respect to previous payments, my lords, we have clarified this earlier occasion also. In the meantime, it has been cleared, and pending wages have been cleared by the state of West Bengal, my lords. At the present moment, my lords, we're considering the specific issue of prospective implementation of the law. Whatever has happened, my lords. Today onwards, how the law can be prospectively implemented
Wait.
for that.
We'll come back to you. Solicitor General, one issue. There was a direction that pending payment of and material payment, wage payment, material payment, if any, prior to the order dated 9th March 2022, will be released by the central government. That was the understanding. Now, two issues arise. So, if there was another direction issued to the state government in that order dated 9th March, in paragraph 10, subpara 2i's, which the state government is contesting. They have filed a supplementary affidavit, they are contesting. Our query is twofold. Whatever has happened, has happened. Let us say that 80% is illegal. You draw a line and you have a cutoff date. Because now this scheme has not been implemented for close to more than 2.5 years in the state.
More than 3 years, my lords. 3 years, 2 months.
So therefore, let us make a beginning as, let us say, by July or August 2025. Prospectively, you start. That is why we said, what are the checks and balances you could make? You put a nodal officer of the central government who will disburse the funds. He will scrutinize the application, because you cannot suspend the implementation of the central scheme.
May I make, in this regard, may I make a respectful submission?
Yes.
In view of the action taken by the central government on a proven fact of misappropriation on the release of the central government fund, an action has been taken under section 27 of the Act of 2005 Act.
Yes.
It is true that the scheme cannot be indefinitely stopped. That's true. But when an action has been taken under section 27, state government has been asked to satisfy by filing one after other action taken report, and unless we are satisfied whether the central government will release funds further. That is the question, Lordship will kindly decide. Kindly see the scope of section 27.
Their stand itself was 22 compliance report has been filed. 22 times they have filed compliance report. So we are not saying anything on that. For the present, we will say that all was not well at the earlier point of time. You please have a cutoff date. Prospectively, you implement the scheme from August 2025. That will be beneficial to, that will be honoring the statutory mandate.
I'm grateful, Your Lordship.
And you impose any condition. You will say that you will not release the fund to the state.
Milord, could I,
on the last occasion,
may I make one submission, Milord? For your Lordship's assistance, Milord, now, Milord, the central government, Milord, has come out with a portal, National Electronic Fund Management Portal, under which, Milord, the money would be directly transmitted to the accounts of the beneficiaries, Milord, electronically. Therefore, nodal officer and all, Milord, that would also, Milord, may not be required. My learned friend may take instructions on this also. But this is what, Milord, I wanted to say.
No, I think, sir, that will be a better option, sir.
That is the system that is in place, Your Lordship. If I may put this is a system that is in place since 2016, Your Lordship. Money, wage, so far as wage component is concerned, my lords, it is directly transferred from...
The central government stand is that there is a clear proof of misappropriation. Therefore, I will not release until things are clear. For the present, we will accept their stand to be correct, because illustratively or factually it has been established, at least in 4 districts as of now, there has been irregularity.
My lords.
So our endeavor is to ensure that the scheme gets implemented prospectively.
My lords, I'm grateful, my lords.
Parallelly, they will proceed with regard to the past action.
I'm grateful.
People recover amounts, remitted to the fund, etc. Let them do. That will be proper, sir. That will be
My
proper.
lords, I'm grateful.
May I just, pursuant to your lordship's observation on the last occasion, may I just now repeat, your lordship had been pleased to observe on the last occasion, there should be a transparent procedure for looking into the investments made by the government of India under the scheme, supervision of not to misappropriate again, which has occurred and admittedly done. Now kindly come to page 6 of our report. Page 6 at the top.
I cannot have any objection to this.
Below top, state should ensure recovery for all such works where due process was not followed.
Yes, they will do. They will do.
And my lords had been pleased to hold on the last occasion on a finding of the nodal officer's report and also the admission of the state in their
What
affidavit
is saying prospectively?
555 writ petition that there is misappropriation and total amount is this quantified. So what should procedure shall we follow for disbursement and maintaining the accounts?
Let them take all measures for
Wait. Shamim, wait, please. Sir, page 6, 1, 2, 3, 4, 5, 6, 7. All directions will be implemented by the state. But those directions are in respect of things works which have been alleged to have been allotted 3 years before.
My lords, I'm grateful. Yes.
And what about the future? Then your lordship had been pleased to observe on the last occasion.
Sir,
there must be some.
please implement it prospectively. We will say that the scheme may be made operational from August 2025. At the same time, whatever is the observations, directions given by the central government in this report should be strictly implemented by the state, the investigating teams, the court monitored team, everybody will work. These are all things which occurred prior to 2022.
I'm grateful.
And then kindly also grant leave to the central government to have an overall supervision of the disbursement of the fund and payment.
Sir, that is what the learned Advocate General also suggested. Please, we don't want to put our hands anywhere. Because the moment we put our hands, there may be an allegation that there is a likelihood of embezzlement, likelihood of misappropriation. You deal directly. The DM will give the names of the employees. Probably they'll upload the work. You have said blanket permission for land development should not be done. And DPC may be directed to accord sanction on a case-to-case basis. Yes, on all these directions, they will strictly implement. And the fund to be transferred to the beneficiary account. And where they can verify whether the beneficiary is available, it can be recorded. You evolve whatever procedure, but please implement this.
Yes, kindly grant that liberty.
Yes. Reference may be made to the order dated 10th April 2025, wherein there were two sets of directions issued, one to the appropriate authority of the central government and one to the state government. For the present, the direction given to the state government is not taken up for consideration as the written instructions with regard to such directions is awaited from the appropriate authority of the state government. The relevant paragraphs of the order dated 10th April 2025 are quoted here and below. Paragraph 10 of the order dated 10th April 2025. Paragraph 11.
Labor budget.
Labor budget for the
in response to the issues which were pointed out in the above paragraphs, the Undersecretary to Government of India under Ministry of Rural Development Department of Rural Development within bracket Mahatma Gandhi NREGA has filed an affidavit. In the said affidavit, the directions which were issued in the aforementioned paragraphs have been dealt with in seriatim, and it will be beneficial to quote the relevant paragraphs of the said affidavit. Please quote paragraph 6, paragraph 7 of the affidavit, whole paragraph 7, It runs to 3 pages. Paragraph 8, 9, up to paragraph 9. I think Mr. Tiwari can give a soft copy of this.
Yes.
So that when they retype it, there should not be any.
Yes. Dial supply.
Yes. It is not in dispute that certain irregularities have been pointed out by the central team in the matter of disbursement of the wages under the centrally sponsored scheme. Action has been initiated, recoveries have been made and remitted into an account which is being remitted, and the recovered amount is lying in the state nodal account of MGNREGS West Bengal. In the affidavit filed with the authority, as quoted above, it is stated that the said amount has to be remitted to the Consolidated Fund of India, and accordingly the state government should remit the recovered amount through a demand draft drawn in favor of the Pay and Accounts Office, Ministry of Rural Development. At this juncture, the endeavor of the court is to ensure the implementation of the scheme in the state of West Bengal, which has been kept in abeyance for the past close to 3 years. It cannot, none can take a stand that the person who had obtained a benefit illegally should be allowed scot-free, and that he should enjoy the benefits which he had obtained by adopting illegal means. Such of those persons have to be dealt with firmly, and whatever disbursements have been made in those favor, in such persons' favor or in fictitious persons' favor, have to be recovered, and there can be no second opinion on this issue. At this juncture, the court is concerned about the implementation of the scheme in the state of West Bengal prospectively. The scheme of the Act does not envisage a situation where the scheme will be put to cold storage for eternity. There are sufficient powers vested with the central government to inquire into irregularities or illegalities in the manner of disbursement of the wages or in the manner in which approvals have to be granted, etc. However, there can be a line drawn between past actions and future steps to be taken to implement the scheme. This, in the considered opinion of this court, would be in public interest and would subserve the object and purpose for which the Central Act was enacted. Therefore, while allowing the central government to proceed with the inquiries as recommended by the central team, not only in 4 districts, but also in other districts, as mentioned in the affidavit, paragraph 7 of the affidavit, para 7, as quoted above, this court directs that the scheme be implemented prospectively with effect from 1st of August 2025. While doing so, the appropriate authority of the central government is fully empowered to impose special conditions, restrictions, regulations, etc., which have not been imposed in other states in the country, so as to ensure that no illegality or irregularity occurs while the scheme is being implemented prospectively from August 2025 onwards. The learned Advocate General submitted that the payments are to be made through a national portal and there can be no intermediary in the matter. As observed by us, since irregularities have been found, committed have been identified, recoveries have been made, the matter is a serious issue which cannot be lost sight of. Therefore, while implementing the scheme in the state of West Bengal, prospectively from August 2025 onwards, the central government and the authorities of the central government who are in charge of implementation of the scheme are entitled to impose special conditions so that to ensure that whatever had occurred 3 years prior should not recur.
Yeah.
Full stop. Necessary steps be taken in this regard and special directives be issued and communicated to the state government, and thereafter the directives state government which also shall contain the specific directions to the district magistrates. Apart from that, the issues which have been pointed out in paragraphs, in para 7, subpara 2.
Subpara 1 to 7, my lord.
No, wait. One is recovery, sir. Subpara 2, namely that blanket permission for land development work should be stopped and DPC should be accorded sanction on a case-to-case basis. The other subparagraphs,
kindly similar paragraph 5 also.
4 and 5.
Last paragraph, bottom.
No, this recovery, sir. Prospectively, I'm saying. 7, you come to 7. State to ensure CIB at every work site. What is CIB?
Central investigation.
Central investigation, CIB. No, it's not central investigation.
So now blanket permission will not grant. Apart from that, the central government would be entitled to impose any other special conditions that would warrant and ensure that the scheme is effectively and properly implemented in the state without giving any room for any irregularity or illegality being committed. The state shall comply with the directives. State shall strictly comply with such directives that
Citizen Information Board.
And such directions which may be issued by the central government are non-negotiable and they have to be accepted ipso facto by the state government and implemented. Only if this is done, the citizens of the state of West Bengal will be benefited, and there will be works can be performed, and they can be paid the wages which are in effect minimum wages, and the rural population which is to be benefited out of this would benefit and this payment would be a succor, SUCC, to the rural population in the state.
Well, CIB is Citizens Information Board, CIB.
All right. Any other condition also?
And recovered amounts will be transferred to the central.
And the other thing which your lordships had been pleased to observe on the last occasion, which you have disclosed, that the recovered amounts shall be transferred to the consolidated fund of.
That we have recorded. Full stop. With regard to other aspects, the court will take up will consider on the next hearing.
Millards, unemployment allowance issue, Millards, with respect.
You do, sir. Wait, sir. Wait.
I'm grateful, Milord.